when you're thinking about estate planning for your family, it really consists of these foundational documents that every adult needs, ages 18 to 108. And that's your will, a financial power of attorney, so you can choose who makes financial and legal choices for you when you can't, healthcare power of attorney, living will for end-of-life choices, and guardianship nominations if you have minor children, so short-term and long-term guardians.
Hey, this is Chaz Roberts. I'm a personal injury lawyer. It's my passion to bring the law to the people, and that's the purpose of this podcast. You are listening to Law Have Mercy. Unless you've been living under a rock, you know that AI, artificial intelligence, is all the rage right now. That's why I am especially excited about today's sponsor, Lawyer.com. They've come up with $1 million AI challenge where they're asking people worldwide to pitch their best AI solution or idea between now and July 19th for a chance to win a $1 million investment exclusively for legal technology products, services, and solutions. The winning pitch will be a strong and well-developed pitch that includes AI execution capability in the legal space, marketing potential, scalability, etc. Think Shark Tank. Don't miss this potentially life-changing chance to have Lawyer.com invest $1 million in your product or idea. Check out the link in the show notes for all the details, including specific requirements for your submission. Thanks again, Lawyer.com, for sponsoring today's episode. So our next guest comes. I'm very pumped up about this episode because several people have asked us specifically about estate planning and elder law. And so we called Ms. Julie, and she is rising to the challenge. Julie Rosenzweig. Did I say that right?
You did. Great job.
All right. It took me a few times to practice. But so Julie handles estate planning, elder law, and what exactly is that?
Estate planning is any planning that you do to protect your loved ones in the case of your death or incapacity.
And is elder law a sort of subset of that?
It is. Elder law is more advanced planning for people who want to protect their assets and still qualify for Medicaid to pay for their nursing home.
So what we had a whole class on this in law school. We talked about wills and successions and that kind of thing. So I think when people think about a document needed, that they need to leave stuff to loved ones, they automatically think of a will. Is that a basic document that you use?
It is a basic document we use, but when you're thinking about estate planning for your family, it really consists of these foundational documents that every adult needs, ages 18 to 108. And that's your will, a financial power of attorney, so you can choose who makes financial and legal choices for you when you can't, healthcare power of attorney, living will for end-of-life choices, and guardianship nominations if you have minor children, so short-term and long-term guardians.
And so I think some people think that, well, some people don't have any will or any type of documentation, but I think people start thinking about a will as they get older in age. When do you think that adults should really start thinking about some of these documents?
When they turn 18.
When they turn 18.
Yes.
Oops. Well, I'm not doing very well, Julie. Maybe we'll have to talk after the podcast.
I know. 68% of American adults have no estate planning in place at all. So you're not alone. You're in good company. So when we turn 18, our parents no longer have the legal authority to access our healthcare records, our educational records, or our financial records. And not many 18-year-olds are truly prepared to set out on life without any support from their parents. And a lot of us want to continue to support our recent graduates during that time. And so we actually provide for our clients what's called a grad plan for a set price. We draft these documents for recent college graduates so their parents can be what they need them to be for them during those years right after high school. If they're worried about them in the dorm, they can have access to their dorm room. If they're concerned about their mental health or their emotional health, they can check on their grades, things like that. So those things are really necessary. And then a lot of people think they need a will when they start having children, when they start getting older, or when they actually get some money. But truly, we all need to be the one to make the choice about not only who's going to get our stuff when we die, but who's going to care for us, who's going to make decisions for us if we can't, if we lose the capacity to make decisions, or like we saw during COVID, if we're on a ventilator for 3 months, who can access my bank account to help pay the mortgage, those kinds of things. It's so important that we as adults make those choices and don't leave those decisions to a complete stranger, to a judge.
That's really interesting. I didn't think about that. So if you're a minor, obviously your parents by law have certain rights and access to your documents and even your bank accounts and stuff like that. When you get married, your spouse will have access to certain things, but no? Is that, so you're
I certainly hope not.
TMI?
For anybody.
No, I'm kidding.
No, just because you're married doesn't mean that your spouse can speak to or have any access or information about your financial assets that are held in your name only. So your individual retirement account, your bank account, checking account, your investment accounts with your broker, any of those things, that's unless you have a durable power of attorney, allowing your spouse to also manage those assets and have access to that information in the case of your incapacity.
And not just that, a power of attorney, if the spouse has to go overseas on a work trip and they need to access some money out the bank account or make some type of decision affecting the family, maybe they're closing on a house, maybe they're buying a rental property, something. Without a power of attorney, the spouse cannot act on behalf of the husband, of the other spouse, correct?
Yes, that's correct. So we always think about it in the situation where if something happened to you on the way home from work and you didn't make it home, could your other spouse, could your partner pay the bills? Can they obtain, medical care for the child that might require the notification of both spouses? If something happens to both spouses, do they know who they would want to raise their children? Do they have the proper legal authority to do so? If you have a small business, is there somebody else at your business who can make payroll, who can pay vendors, who can keep the doors open until you're able to come back? Or if you're not able to come back, who can run that business until it can be sold or passed on to your heirs? So there are a lot of instances where estate planning comes into place to protect your family that has nothing to do with passing on your assets to another.
That's interesting. So as a power of attorney, you can also, I didn't realize you can designate legally who you want to take care of your children in the event that you pass or you and your spouse pass at the same time. You can designate your preference on who should take care of them.
Absolutely. So we suggest all our clients execute that long-term guardianship nomination. That's what you're talking about, who's actually going to raise your kids, and name who you want to serve, and then 2 backups to that person in case they can't serve or they're, for whatever reason, no longer able to. But then we also designate short-term guardians, and those are the people who can take custody of your children from school or daycare, or if they're home with a babysitter and you and your partner don't make it home from a date night, they can show law enforcement that they have the legal authority to take possession of those children until the long-term guardians can get there, if they live out of state or far away, or if they're not able to be contacted. That's so important because it prevents your children from ever being taken into the custody of the state, even for a short time.
And the last thing you want is a war between the grandparents.
Yes.
Mama's grandparents and daddy's grandparents. You
For
don't,
sure.
You don't want.
For sure, because if a tragedy happens, a lot of people will step forward to raise the children. And our motto is keeping your family out of court and out of conflict. So by clearly delineating who you want to raise your children and in what order, you really remove a lot of that conflict.
So the general power of attorney is going to have a lot of the transactional power where one person can act on your behalf. I think the legal term is a principal and agent in Louisiana. Yeah, yes. I remember some of that stuff. And the principal ultimately can act on his own, but in the event the principal can't act, you have the agent that's already been appointed by this legal document to act on your behalf.
So the way we draft general durable power of attorneys is that they go into effect the moment they're signed. So some states allow springing powers of attorney where it only goes into effect upon the incapacity of the principal, the person who wrote the document and gave the authority. But financial institutions really don't like those. If they have to rely on that, then they have to do their own investigation to determine if this person's incapacitated, which is really beyond the scope of what they're ever going to do. So they want to know that this is the only person who can act for you, and they can act for you all the time, and they have all these authorities that are listed in that document. That's what they're looking for.
And then the other document, which probably came into play during COVID, is a medical power of attorney.
Well, it's been around longer, but it definitely came into play, yes, significantly during COVID. And the way we draft healthcare powers of attorney, they are documents where you choose not only who you want to make healthcare choices for you. If you can't make or communicate a healthcare choice, that's when it goes into effect. You have a backup for that person also, but then you also list how you want them to choose on a variety of different topics. So we include healthcare directives in our powers of attorney. So on issues such as amputation, autopsy, that's a hard choice to make for somebody else. You're telling your agent, it's okay, this is what I want, and so you're taking that choice off their shoulders and reducing conflict, reducing crisis if anything happens to you.
Because there's a lot of tough decisions that had to be made, right?
Oh my goodness, during COVID, absolutely, absolutely.
And you feel almost, if you're the spouse and we're talking about a breathing tube or a feeding tube, there's some guilt that comes along with making those difficult decisions, right? So
Absolutely.
You may feel in your heart of hearts that that person wouldn't want to continue living in those circumstances, but you feel almost like you're responsible for their death in a way.
Right.
I mean, is that too morbid, or is that
No.
that's the reality, right? I mean,
that's just morbid enough because that is the reality. Yes. And then hand in hand with your healthcare power of attorney is your living will. And your living will only deals with end of life choices where you're terminally ill, there's no reasonable chance of recovery, and any life-saving measures would only serve to prolong artificially the dying process. That's a really specific set of circumstances. So a lot of people are concerned if I execute a living will, they can pull the plug anytime. That's not the case. You would have to be certified to be terminal by 2 physicians, et cetera. That's the basic form that's required by law by the state of Louisiana. It's the same form you'd find at the hospital. The language is required by law. But we incorporate that with our healthcare power of attorney, saying that anything in our healthcare power of attorney is subordinate. It's under that living will. The living will is always going to rule. Whatever you wrote in your living will, that's what's going to be followed with those end-of-life choices.
So on a simple plan, and we talked about power of attorney, we also talked about living will. What about a last testament, final will, whatever you want to call it, where you talk about what happens to your stuff when you pass?
It's always important for you to be the one to choose what happens to your stuff when you pass. If you don't do a will, the state has a plan for you. It's called the laws of intestacy pertaining to a will, last will, and testament. If you die,
and I'm not nearly going to bore the audience with the rules of usufruct and naked ownership. And
well, if you want, interestingly, I do go into that when I talk to my clients because it is boring. It's also confusing. It also has a huge capacity for conflict within your family, especially if there's a blended family. So there are many reasons for everybody to write a will, but especially if you have a blended family. You absolutely want to make sure everybody's treated fairly, everybody feels heard.
And what was interesting when I spoke to a family lawyer on this podcast, he said that a majority of his clients now, when they talk about child support, child custody, it's no longer married couples. And so marriage brings on certain rules through the from intestate succession once you die without a will. Those people that live together and have children should especially get a will, right? Because the rules of marriage aren't going to protect them.
That's very true. If you are in a relationship with somebody and y'all have a family and there is no marriage there, a lot of protection is lost. You might assume, oh, this is the parent of my child. They'll absolutely be getting my bank account, my house, all these things. But that's absolutely not the case. It'll go to the children. And what's more, even though the other parent is the natural guardian of the child, in Louisiana, we have 2 types of guardianship, guardianship of the person, and guardianship of the property. So the other parent, if they're still living, they absolutely will be the guardian of the child. They won't be the guardian of that child's property. So children under 18 cannot own that property in their own right. So that other parent, not only did they just lose you and they're going through that trauma, now they have to go to court, try to convince a judge they're good with money, show them their credit score, talk about the NSF checks they had in college, and try and prove that they're worthy to handle their kids' money. It's pretty humiliating. It's time consuming, it's expensive, and it's completely avoidable if you did your proper estate planning.
And it kind of, depending on the age of the child, it could create some kind of inter-family conflict, right? I'm trying to convince a judge that I should be in charge of the bank account of the money that I may have made, but he inherits because we were never married.
Oh yes, you can go down a whole bunch of rabbit holes with that for sure.
So when do you think it's the right time to draft a will?
Well, like I said, at 18, but if you've never done any estate planning, now is a good time. If you've done some estate planning or everything I just mentioned, and it's been longer than 3 years since you've had your plan reviewed, it's a good idea to go sit with a estate planning attorney. I know all of my consultations are free. I can't speak for every attorney, but that's how I do it, because I really do want people just to come and get educated and see where they're left vulnerable so that they can make those changes if they have to. But there are certain life events that major life changes that can necessitate an amendment to your plan if you don't have, if you have one in place. And that would be a marriage, a divorce, a birth of a child reaching 18, acquiring a large asset, selling a large asset, any change in your life insurance. All of those things can trigger a need to amend your plan. So just because you write your estate plan, you get all these documents in place, it's not a one and done situation. If you want your plan to work for you when you need it to, you have to make sure that it's updated as time goes on. The estate plan you draft, the choices you make when your children are 2, 4, and 6 are going to be very different when they're 22, 24, and 26. And so your estate plan should reflect that also.
And so even in a married couple, you can still, the couple may come together and say, we want Johnny to have this, we want Susie to have this, and you can actually specify what thing that each of them are getting. Whereas if you don't have a will, you can't give them a specific thing.
That is true. Also, you might have set up testamentary trusts in your will, which is where you have a trust literally in the words of your will. So it's a trust that would hold the property for your children if anything happened to you, if you passed away, but it doesn't come into effect until after you die. So we can talk a little bit about trust right now if you want to, because I do want to kind of explain what a trust is, because I think there's a lot of misconception about trust. Do you want to do that now? Or
I think that trusts are just for the very, very rich people that use these things to keep things out of the hands of the government. I don't know what a trust is. Tell me, help educate me. What exactly is a trust?
A trust is something that's useful if there's any reason why you need to make sure assets are handled in a certain way for another individual. Whether it's because it's a lot of money to a minor child, whether you need to provide assets for a person with a disability who's going to need those assets their whole life, or if you're protecting assets from judgments, creditors, lawsuits, or to qualify for government benefits. So those are the reasons why you might need a trust. And exactly what a trust is, it's an agreement. It's basically a contract between, there's 3 parties to every trust. The settlor, in Louisiana we call him the settlor, other states they call him the grantor or the creator. That's the person who sets up the trust and decides on what all the terms of the trust are going to be, what all the rules are going to be. They put it all into place. And they have an agreement with the next party who's the trustee. And that's the person who holds the asset, legally has possession of the asset, and they manage it and distribute it for the benefit of the third party, the beneficiary, who can be a person or a group of people or an entity like a charity that receives the income and or the principal from the trust. So that was a lot of words and a lot of definitions, but
how about an example so we can figure out the different parties?
So if you have small children and you want to make sure if anything happens to you and your spouse, if y'all both are gone, that whoever is raising the children handles your assets and spends money for your children the way you want them to, then you can set up a testamentary trust. And the terms of the trust, the terms of that agreement would be in your will. And so you would be saying, okay, I want my sister to raise my kids, but you know what? She's really not that great with money. So I want my brother to be the trustee. So my sister's the guardian, but my brother's the trustee. The guardian can be the same person as the trustee. It doesn't have to be. But the trustee is going to have to follow your rules. Kind of the basics that we do for people is that we say you can distribute any assets for the health, education, maintenance, and support of the child, which is pretty broad, and it's purposefully broad so that they can make judgment calls on what needs to be spent. But we do customize these for clients. They can get as specific as they want. Like, I will pay for half of the cost of a used car when they turn 18, or I will only pay for new tires and oil change, something like that. You can pass on your financial values through the terms of your trust and make sure that your children are raised with those same types of values that you would want them to.
It sounds like it's set up to put some guardrails in so they don't hurt themselves or completely liquidate the
Absolutely.
estate.
Right.
So you work your whole life acquiring assets, making money, and you're 55 years old and you have a 22-year-old college kid. You don't want to spoil them if something happens. You want them to work for it, and you
Right.
want them to continue succeeding in life. So you don't want to cripple them with your $2 million estate.
Yeah.
Right? So you put in some rules of the game, and you appoint your brother to distribute some funds when they reach 25 or 30 or
Right.
35, help them with the purchase of a new home, and you're setting out some rules to help them prosper and not cripple them with the wealth you've acquired over time.
Absolutely.
Would you agree with that?
Absolutely. You don't want your gift to become a burden.
You said that so much better. You have all these little phrases. You've said this a few times, right? You've gone through this process a few times, I bet.
I do give a lot of presentations. It's very important to me to educate the public on these topics. My background as a lawyer comes from, I was a family lawyer. I did divorces when I started my practice.
Oh, bless you.
I know, right? I earned my halo. I did a lot of criminal law as a prosecutor and a public defender. And so I saw nothing but family conflict from morning, noon, and night. So I'm very familiar with the types of outside forces that could cause conflict within a family, the internal forces that can cause conflict. A lot of estate planning attorneys come from a tax background. Maybe they were a CPA, then they went to law school. I'm aware that taxes exist. That's not my focus, though. So some trusts and estate planning is done for tax avoidance. And certainly, we do some of that. But the focus of my practice is really on those family relationships and making sure that the choices that we're making doesn't introduce any new conflict or make any of those things worse. But certainly with a trust, even if your child is an adult, there are lots of reasons to protect those assets for them. And when we draft trusts for the next generation, we draft them as asset protection trusts. So certain terms have to be in there, certain decisions have to be made, and then it's protected from lawsuits, judgments, creditors, divorce, any of these kind of bankruptcy, any of these external threats to your children. So you're kind of saving them from themselves.
Can you transfer assets to the trust?
You being who?
Can a person transfer the ownership of a home to a trust, or is that something different?
Yes, so any asset that is capable of ownership, essentially with a few exceptions, can be placed in trust.
Okay, so there are trusts that people can set up to try to avoid taxes. When does that come into play?
So that comes into play when we're talking about estate taxes. And estate taxes for someone who passes away as a resident of Louisiana, we're going to be worried about federal taxes. Currently, there's no Louisiana state estate tax, and I don't see it coming back anytime in the future. So the federal estate taxes, we talk about the exemption level, where if you die owning more than that dollar amount, then you pay estate taxes on whatever's above that amount. If you die owing less than that amount, you don't have any estate tax obligation at all. Currently, the federal estate tax limit, exemption limit, is close to $13 million for an individual. So that would be close to $26 million for a married couple. So if you die owning less than $26 million in assets, you and your spouse, you're all set. You don't have to worry about it. So that level was raised during the Trump administration, and that exemption level, which is really high, sunsets at the end of 2025, and it's going to go back down to where it was before, which is $5 million each, $10 million for a couple. And so any asset you own above that exemption rate is taxed at between 45 and 55%, which is tremendous.
That's tremendous.
It's a huge hit. It's a huge hit.
So if someone inherits $50 million, they pay from the exemption level of 20, what did you say?
26 for a married
26.
couple. Yeah.
So they have to pay close to 50% tax on $25 million.
Right.
That is insane.
It is insane.
So they set up trusts.
They do.
To avoid that.
Yes, and without getting too much into the weeds, it's basically, there's lots of different trust tools you can use to protect your assets from estate tax. But essentially what happens is you're putting whatever would be above that exemption rate into a trust. Whatever's vulnerable to tax, you put it into a trust. Because you're doing that and you're getting the benefit of it not being considered part of your taxable estate, it also can't be considered your asset, essentially. So you lose control over it. So you're completely putting it in the hands of an uninterested trustee. The trustee has to be, there's certain rules about who they can be. It can't be like the trust you just set up for your kids where you're choosing the guardian. It's all in the family. It's all, it's just how you decide to spend the money. Lots of other restrictions on how it can be spent and who can spend it and on whom it can be spent. But it is possible to protect your inheritance from federal estate taxes.
So these are very complicated documents with lots of intricacies that are involved to try to shield some of that estate tax.
Yes, and it's very important to not only work with your estate planning attorney, but your accountant and your financial planner. That's the estate planning team. We all get together to make sure we've done it correctly, because you're facing such a huge tax liability, and the laws change all the time. So
I bet.
That's another reason to have your estate plan reviewed. What you set up 10 years ago might not have the same outcome you want based on today's laws, if estate taxes are something that you're worried about. So
the majority of people probably don't have to worry about estate tax.
The majority of people today, no. But it's interesting to note, at the end of the 90s, like in 1999, the estate tax exemption rate was $300,000 for an individual. So many people had to worry about that. So that has been a primary focus of estate planning attorneys for a long time, for good reason. Right now, it's astronomically high, kind of artificially high, I guess you could safely say. So it could be in the future that exemption rate comes down to a level where it is something that more people have to worry about. But today, someone coming in my office right now, it's not something everybody has to worry about. However, in our plans, if we do have a client who has assets anywhere near where the estate tax exemption rate has been in the past 10 or 15 years, we include provisions in our will or trust, whatever they want to draft, where if they do have assets that are in danger of estate tax, then that type of trust can be drafted. Their executor can draft that kind of trust and protect those assets, and we're all safe.
One topic while we're on the subject of taxes, because I think that it's related in a way, right? I've gotten this question 1,000 times. Chaz, my parents are getting older. They're worried they're going to have to go to the nursing home. We think that they should donate their property to us, to the kids, because we don't want the nursing home to sell their house and take all the money. Have you gotten that question? I certainly got that question. What do you think is the proper response to that?
Please don't donate anything to your kids if you think you might need to go to a nursing home. Nothing. Not a house, not a car, not a piece of jewelry, nothing.
Why?
Because of the rules on Medicaid eligibility to qualify for a nursing home are the way they are. Medicaid will look back 5 years, 60 months from the date of your application for Medicaid, and they're going to see, did you give away any asset for less than fair market value in return? And if so, they're going to attribute the value of that asset to you. So if you gave your grandchild $20,000 for college, you don't have that many anymore. Medicaid is going to attribute that to you and say, oh, no, you have $20,000 because you made that gift.
Was it at one time less, like 3 years, and then it went out to 5 years?
Absolutely. It used to be no years a long time ago. And other states have different time requirements. Medicaid is a program that's administered by the states, so it's different in every state. So it's so important that if you read something online about Medicaid planning, you make sure it pertains to Louisiana. 99 times out of 100, it does not pertain to Louisiana, so please don't believe anything you read online, basically, is what I'm saying. So I specialize in elder law in that type of Medicaid long-term care planning, and it's real important to point out we're only talking about Medicaid, not Medicare. Medicaid is the only program in the state of Louisiana that's a government program that will pay for a nursing home. Medicare will pay for the first 20 days, maybe the first 100 days if you have a certain plan, but that's it. Medicaid also does not pay for assisted living or in-home personal care aids. So we're just talking about nursing homes and we're just talking about Medicaid.
So you're better off keeping your cash or keeping the home that you can sell potentially, or get some type of loan on your assets or something to pay for assisted living care, rather than divulging all your assets and that you will not have anymore, but that Medicaid is going to see anyway.
Yes. So when our clients come in and their age is 55 to 60, that's when we start talking to them about Medicaid planning, because the more time you have to do Medicaid planning, the best choices you can make.
Let me ask it this way. If you're 55 and you know you're not going to go to a nursing home for the next 5 years because you're still young enough and the clawback doesn't really come into play, is that a proper time to donate the house?
So any kind of Medicaid planning that you do, you definitely want to make sure that it's done in conjunction with, after consultation with an estate planning attorney, because that might not be the best option. To qualify for Medicaid, you have two things you have to consider: your assets, but also your income. And there's asset limits and income limits. Your asset limit is $2,000 unless you're married, and it's $137,000 then, $139 when you put them together. So basically, it's a strategy game of converting assets that are not counted as assets, because Medicaid doesn't count everything as an asset, converting your countable assets to non-countable assets. That's what you do if you have less than 5 years. If you have more than 5 years, we can protect everything. And not only so that you can qualify, but then after you pass away, Medicaid is required by federal law to try to recoup the cost of your care from your estate. So just because you qualified for Medicaid doesn't mean Medicaid will not come back, and that's where that clawback term comes in. Try and claw back what they paid for your care from your estate. So if we have more than 5 years, we can protect everything from being eligible to protecting your estate from clawback. If we have less than 5 years, very limited for on the clawback side, but it's likely we have a much better chance of qualifying you for Medicaid.
And also, fun aside, if you bought the piece of property 30 years ago for $10,000 and now the property's worth $150,000, if you donate the property, your heirs will, and they want to sell the home, will pay taxes on the difference between $10,000 and $150,000. Whereas if you inherit it, you get the tax basis of the asset at the fair market value at the time of the inheritance.
Correct.
Is that right?
Yes, the step up in basis.
You got a step up in basis if you inherit the property rather than receiving it through a donation.
Correct. A spouse will get a step up in basis from their spouse, and the children from that spouse, from that parent.
So if you are listening and you think that it's a good idea to donate your property to avoid the nursing home taking all your money, it's a bad idea. It's a better idea to spend your time at an estate planning attorney's office than trying to donate your property or do something that you read off the internet.
That's right. And when we first started talking about this, I mentioned fair market value. So the fair market value, they're not kidding around about that. Medicaid will pay for an appraisal of your home, your car, your Picasso, whatever it is that you donated. And if their appraisal is different from yours, it doesn't matter. They'll go with their appraisal. So before you sell any asset, within that 5-year window. Always get an appraisal. You may be selling a tractor to your neighbor or something like that, and I think that's worth about $10,000. Go ahead and do the work and get an appraisal, because if Medicaid comes in and says it was worth $20,000, then you're attributed $10,000. Same thing for vehicles. When it comes to selling real estate, a lot of times you will have somebody who bought that house in the 1960s and they have no idea what it's worth. Don't just have a realtor run the comps. Actually get an appraisal for that property, because I promise you Medicaid will.
We talked about adults, but let's talk about elders specifically. What should, if they think that they're going to need long-term care, whether it's at home or in a nursing facility or something, what should they be doing at this point?
Really, the first thing, and I hate to keep coming back to this, is talk to an estate planning attorney, because the answer to that question changes with the facts that we're given. It's very fact specific. So knowing what needs to happen with each of your assets is what you need to do. You're only going to know that if you talk to an estate planning attorney.
And there's a million factors that you consider.
There's a million factors that you consider, because some of these protection strategies require a good relationship with your children, basically. And that's just not available in every family. That trust or the competency and ability of the child to serve in that role. So a plan might make financial sense, but it's never going to work out in reality. So there are a lot of things that, a lot of factors that go into it. I do presentations on this frequently. I do webinars on this frequently. So I try to get this information out as much as I can, just to prevent people from making incredibly costly mistakes.
One thing that I've noticed, like I've handled some wrongful death cases, and I'm an attorney, so I get some calls. I've noticed that people that have someone they trust and they put them as a cosigner in their bank account, that has helped in the event of someone's passing, that someone can actually access their funds to pay for a funeral and to pay the car note that's coming up and things like that. Do you recommend adding a cosigner to a bank account?
So if you're talking about just a signature on the bank account, not a co-owner.
Correct.
It depends on the financial institution, because sometimes that designation does not survive death of the principal. Sometimes it does. I would never recommend having a co-owner on the account be somebody whose money's not also in that account, because then all of your assets, all the funds in that account are available to the creditors of the other party you have. So if you have one of your children as a co-owner of your bank account, so that they can write bills, write checks, pay bills, all those things, it's vulnerable to anybody who needs to get money from them. So a pay on death beneficiary is really what you want if you're looking to have access to cash, soon after a person passes away. Everybody should have a pay on death beneficiary designated for their checking, savings, CD, money market, these kind of bank products. It's very easy to do. They might not have asked you that when you set up your bank account, but if you go in and ask them, they'll find the form eventually. And that way, that person generally has to show the death certificate and their driver's license, and then they can have access to those funds in that account. It's also important to note, though, that a pay on death beneficiary becomes the owner of those funds, not just the controller of those funds. So if the majority of your assets, you have $100,000 in a checking account and you want your son Bobby to manage it, don't make him the pay on death beneficiary, because then Bobby gets $100,000 and his 3 siblings get nothing. So, these are ways where it's really easy to get it wrong, but you do want to make use of the simplest means possible to carry out your wishes, but it's really easy to do it wrong. Just like any kind of do-it-yourself estate planning, downloading documents off on the internet, just bringing them to a notary, 9 times out of 10, that causes your family more trouble, costs them more money than it saves.
One thing that is kind of outside of the succession of what we think of being within the succession and things that we can control is life insurance policies. I have noticed in my practice that people life events happen like divorce or the death of a loved one, and people don't change the name beneficiary on the life insurance policy.
Right.
Can you talk about that?
Yeah. So all of our assets either will pass through the probate process when we die. That's the process where the court puts your heirs in possession of your stuff. or they pass outside of the probate process. That's the two ways property passes when you die. What passes outside of court? Anything with a beneficiary designation. So life insurance, qualified retirement accounts, annuities, pay on death beneficiary. Anytime you've said this person gets this when I die and did that on a form, that's a beneficiary designation. So those people get that asset, and that's not even looked at by the courts. Everything else passes through probate. Your home, your checking account, savings account, your brokerage account, which is not a qualified retirement account. That's just if you used post-tax dollars, just your income that you've already paid taxes on. Retirement accounts are funded with pre-tax dollars, generally
A
speaking.
Fidelity account, a Vanguard account, an Edward Jones account. That's a brokerage account.
Correct. You just bought some stock in AT&T or whatever. That passes through court. So,
so if you're listening to this podcast, the number one thing you need to do after you call Julie and set up wills and trusts and powers of attorney is you need to call your life insurance agent and make sure that the named beneficiaries are the proper parties, especially if you've undergone a divorce or anything like that.
Right. So when it comes to divorce, in Louisiana, certain assets, certain designations, certain nominations will become nullified by the divorce. In a will, if you've named your spouse as your executor, when you're divorced, that nomination terminates. If you've left any bequest to your spouse, I'm going to leave half my assets, $10,000, whatever, that bequest is nullified. It goes away. It's never going to be given force. If you make a will after you're divorced, and then you put your ex-spouse in there for some good reason, that will be honored. Life insurance, it depends on whether that spouse also contributed to the premiums. It's kind of a community property question at that point, but it also depends on the rules of that company. The company is going to, each life insurance company has different rules about how that's treated, but you do run the risk of your former spouse remaining the beneficiary of your life insurance. 401k, same deal. There's a community property element to it. So the answer is it depends, and absolutely you do need to review those things, because not every divorce attorney tells you that or goes through that with you, but you do need to do it. And then also, if you have all your beneficiary designations where you want, but you change something in your estate plan, like you drafted a testamentary trust or some other kind of trust, and you want that to be the beneficiary of that asset, you then have to go to that company and change it on the paperwork too. So your beneficiary designations, when your Edward Jones guy calls you for your annual meeting, please meet with them, because those are one of the things that you update at that time.
It's a 5-minute form that can save your heirs years of litigation.
Absolutely.
Why do things have to go through the court process once you die to give ownership of your house and stuff like in your bank accounts? Why does that all have to go through the court process?
Some people define the probate process as a lawsuit your family files against your estate for the benefit of your creditors. Every state does a little bit differently, but in Louisiana, we have a real strong public record rule. We need the public to be made aware of the assets of this person who just died in case they owed somebody money, so that person can come and get their money from their assets. Essentially speaking, in other states, there are some types of ownership that avoid probate, like joint tenancy, tenants in common, those kinds of things. I won't even start to explain those because I don't really understand them, but we don't have that in Louisiana. Everything goes through the probate process unless it has a beneficiary designation or unless it's been put in a revocable living trust, which is a whole new kind of trust that is set up primarily to avoid probate.
Because it's a process, and it's an expensive process.
Revocable living trust?
No, the succession, going through a succession. I mean, it's numerous filings. You need a judge to sign off on it. It costs a lot of money. We have to do a full accounting. We have to list values. I mean, it's an ordeal. And
it is an ordeal.
Most people don't expect that to inherit the property, the acreage in Vermilion Parish, that they have to come up with $5,000 out their pocket to hire an attorney to do it.
Right, because the proper forms do have to be filed with the court. It's not coming to you any other way. That's just the long and the short of it. There is one exception to that, and that is in the case of a small succession, where if the person died owning less than $125,000 in assets here in Louisiana, and they did not have a will, and they were relatively free from debt, then the family just has to sign a certain affidavit, which usually has to be prepared by attorney also. But once that affidavit is signed, then that transfers ownership of that asset. And then there are also if the decedent passed away owning any amount of assets, but it's been more than 20 years, you can also do a small succession affidavit. If the primary property has been damaged by a natural disaster, you can do a small succession affidavit. So a lot of these rules were expanded after Katrina to deal with heir property.
So if you have an estate, if grandpa has an estate that's less than $125,000 in value, there's a much easier process called a small succession that you file with an affidavit without opening a large succession.
That's correct.
Well, Julie, this has been very helpful. I learned a lot. Where can people find you?
My website is very easy. It's planwithjulie.com, Plan. So you don't have to know how to spell Rosenzweig to find me, which is great. You're welcome. My office is in Broussard. It's basically right next to the Celebrity Theater, so near Albertsons Parkway and Highway 90. And I also do frequent presentations. So whether that's in person at a presentation or through webinars, those will all be listed on my website.
Thank you so much, Julie.
My pleasure. Thanks for having me.
Absolutely. Hey, it would mean the world to me if you subscribe to the podcast and leave us a 5-star review. It helps keep the show free, and it helps us book better guests to provide more valuable content to you. None of the opinions expressed by my guests are that of my own, and nothing we talked about creates an attorney-client relationship or could be construed as legal advice. Hope you enjoy the show.